My mom did a quitclaim deed with survivorship. So her name is first, then comes her grandson, 34, and granddaughter, 24. Will it go straight to them when she passes with no issues? So there are several different types of deeds that can be executed in Florida. One option is what's called a joint tenants with rights of survivorship. So this is the particular deed it sounds like you're talking about, since you're saying it's a deed with survivorship. So a deed with survivorship rights, when we're talking about people who are not married, that's going to be your joint tenants with rights of survivorship. And yes, the way that type of deed works is rather than each individual listed on the deed owning a certain percentage or portion of the property, rather than having it be that way, instead it's as if anyone listed on the deed, or everyone listed on the deed, in this case 3 people, have 100% interest in the property. So the way that works is, assuming your mom were to be the first one of them to pass away, then the other 2 survivors on the deed would then just continue owning the property. No issues, I mean, for the most part, but we're going to talk about issues in a minute. But they would, yes, meaning if you mean by no issues, no probate, not having to fill out additional deeds or do additional forms. Yes, essentially one person passes away, the other 2 people who are listed on the deed as joint tenants would just go on owning the property jointly until one of them passes away, and then the sole survivor would go on just owning the property, 100% of the property as a whole, again without the need for probate. Now, a couple things to go over with this type of deed. One, the deed itself does have to use the specific language that it's joint tenants with rights of survivorship. I say this because this has happened more than once in my practice, where someone thinks they signed a quitclaim deed that's for jointly owned property, but when they bring it to me to review, it just has the owner's names on it. So let's take this instance as an example. There's 3 people who are listed on this deed. If the deed doesn't specifically say that they are joint tenants with rights of survivorship, then they're not joint tenants with rights of survivorship. Instead, they're going to be considered what's called tenants in common. And tenants in common is very different in the sense that rather than them all sort of owning the whole, and when one passes away, the other 2 just own it, and then when the other one passes away, or when another one passes away, the last one to survive owns it. That's not how a tenants in common deed operates. It's as if they each own an undivided 1/3 interest. So it would be 3 people each owning 1/3 of the property, and when one of them passes away, their portion, their 1/3, has to go through a probate in their estate. When another one passes away, that 1/3 goes through probate in their estate. And when the final person passes away, of course, would have to go through probate in their estate. So these can also be tricky from a probate perspective, because if you have a 1/3 interest going through probate and the people inheriting it are different from the people who are already listed on the deed, you're going to have additional owners. It could create problems and issues, especially if someone's living in the home, or if you do want to sell the home and not everybody agrees. So it's very, very important that you make sure who's ever drafting this deed does include that language, because you might think it's joint tenants, but if it doesn't have the specific language, it is not joint tenants. Another sort of issue here that I see all the time in estate planning, people think, I'm going to do this the less expensive way, maybe the quicker way, and just do a quitclaim deed and throw my child or my grandchild or a couple people on the deed so the property can pass to them without going through probate. Sounds like a great idea, right? You could actually be doing your child, or your grandchild in this case, a disservice. Because here's what happens when you add someone on the deed of your property as a joint tenant. When they take over the property, or when they are added onto the deed, I should say, because I don't know who's living in the property in this instance. But let's say that it's your mom's living there now, and she's going to live there for the rest of her life, and her grandson and her granddaughter are not living in the property, but she just wants to give them the ability to sell the property when she passes away. Maybe they're never going to live there. Well, in that instance, by adding them to the deed, what she did was lock them into whatever she purchased the home for as what they have to use as their tax basis when they sell the property. So this is what that looks like. Let's say when your mom purchased the home, it was many, many years ago, and she purchased the home for $100,000, just by way of example. But now she's lived a very long life. Let's hope that's the case. And when she passes away, the home is actually worth $500,000. So there was significant appreciation in value, which we typically do see over time with real estate. And we have seen this to a much larger extent recently in Florida. So what happens then is when she passes away, if her granddaughter and her grandson decide they're going to sell the home because they want to just take their inheritance now, when they sell the home, there's going to be capital gains tax owed on the difference between what their grandmother originally paid for the home, right? The $100,000 in my example, and what they end up selling it for, which if it's valued around $500,000 at the date of her death, and that's what they sell it for, there's going to be a $400,000 profit there that was realized, and there needs to be capital gains tax paid on that profit. Versus another way to do it, which is if you're in Florida, you can do a Ladybird deed. I have many videos on these. So rather than just simply adding two of your grandchildren to the deed as a joint tenant with rights of survivorship, or joint tenants with rights of survivorship, instead, you put them on the deed as beneficiaries. That's what a Ladybird deed does. The property stays in the original owner's name, but when they pass away, the property can then pass to beneficiaries listed on the deed. When you do it this way, instead of just adding them as joint tenants, they actually get what's called a step up in basis for tax purposes. So they no longer have to use grandma's purchase value as their tax basis. Instead, they get to use the value of the property on the day that grandma died as the tax basis. So much different example. In the previous example that I just gave, when grandma purchased the property, she paid $100,000, but when she passed, it was $500,000. So in this second example, had they used a Ladybird deed, or had grandma used a Ladybird deed instead of the quitclaim deed with its joint tenants, well, when they inherit the property, it's worth $500,000. They get to use the $500,000 as their value for considering taxes. So what that means is if they turn around and sell it within 3 months, 6 months, maybe even up to a year, it's probably going to be around that same value, the same value that it was when grandma died. So if they're using $500,000 as their tax basis, but they sell the property for $500,000, well, then there's no profit there per se for them to be taxed on for capital gains. However, they do receive the proceeds from the sale of the house. And if grandma paid off her mortgage and there wasn't a lot of bills associated with keeping the house going until they sell it, and of course no liens on the property, then that's a decent amount of sales proceeds, especially if you don't have to worry about capital gains tax. You do not have that same luxury when you use a quitclaim deed and simply add people to the deed in order to avoid the probate process, which again is usually when I see something like this happening in my office, is when somebody wants a quick way to do estate planning. They maybe don't want to pay an attorney to sit down and talk about their options or what is best down the road. Grandma may be saving some money up front, but you got to look at what cost is that to her grandchildren in the future. So these are things to think about when you're deciding what deed to use. All right, hope this answers your question. Any other questions about deeds or estate planning and you're in Florida, don't hesitate to reach out to us. We're at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.